Maybe Karmelo didn't want to testify. Maybe counsel made a terrible decision. But if the record is silent, the appellate courts usually don't assume incompetence. They assume there has to be some reason behind it. Now, could Karmelo eventually raise an ineffective assistant counsel? Yes, he can do that, absolutely. If a trial counsel failed to investigate and failed to prepare him to testify, and he testified, or failed to object to some obvious legal error, or failed to request the proper jury instructions, failed to challenge the improper witness testimony, or failed to preserve some major appellate issue, then his appellate, and he can do that. They'll look at that. His dream team will look at that. They'd be foolish not to. But will it be easy? No, not even close, because the state's response will be simple. Even if the lawyers made mistakes in this case at the trial level, the evidence is still overwhelming. We got a dead body, dozens of eyewitnesses, a murder weapon, and a confession. So the state will argue that there's no reasonable probability that the outcome would have changed, even if the lawyer was asleep the whole time, much less not objecting enough for you all. That's the wall that they have to climb. So here's the hard truth. Somebody type hard truth. I know y'all mad. Somebody type sell out in the chat room. Boule. Somebody, come on, let's get all them words in. You mad? Be mad. I don't care. Here's the truth. This ineffective assistance of counsel is possible, but it's unlikely on this direct appeal. If it had legs, it's probably later in an Article 11.7 habeas proceeding where the new lawyers can build a record to show what trial counsel actually failed to do. But right now, on this direct appeal, just saying the lawyer did a bad job, it's not enough. It's not enough. And that's what it is. Let me know when you're mad. If you're mad, just turn the channel off. Go somewhere else. Somebody will lie to you. I won't. I don't want you to feel good. I want you to be upset, hot, and bothered. Here. Ha ha. I want you to be good and mad over here. You're going to get this truth. You're going to like it, whether you like it or not. Y'all see my cup match my little picture behind? Look at that. See that little picture? It's nice, huh? Coordinated. But anyway, y'all still here? Y'all still with me? There's a lot of y'all in here. It's a lot of y'all in here. You want the truth, right? That's why I asked you earlier if you wanted the truth. Right? Okay. Let's continue. Shall we continue? I'm saving lives over here, baby. Uncle D is saving lives. Tell you the truth. I ain't gonna lie to you. Right? Some of you all studying for law school, you get ready to go. You can learn something over here, baby. Learn something for free. I'm not even trying. I should start charging y'all for these law school classes, man. I should. This is a level 3. This is a 3L class, appellate lit. But anyway, you know, there's been a big ado. There's been a lot to do with the fact that Karmelo's Anthony jury had no black jurors, no blacks. Somebody type no black, me no black jurors. Okay. But no black, just because you don't have any black jurors in the jury, that's not enough by itself. Now, Karmelo didn't have an all-white jury. It was some brown people, Asian people on there, okay? But hell, even an all-white jury, standing alone doesn't automatically prove the Batson violation. The Constitution doesn't guarantee a defendant a jury of his race. The issue is how the jury became, that's it. The only issue is how the jury became all white or how all the blacks were excluded. That's the reason. Shout out to 99 Problems. And let me explain something, because I want to talk about Batson. Somebody type Batson in the chat room. Batson, like Batman, Batson. It was about stopping prosecutors from doing indirectly what the Constitution says they couldn't do directly. Batson v. Kentucky. This is a U.S. Supreme Court case. It was issued in April 30th, 1986. I remember when it came out because my daddy talked about it. I remember the conversation he had with it was revolutionary. Like, wow, it's amazing. Like, damn, really, daddy? Yeah, it's amazing. Yeah, it's all the black people. You go down there and try a case, there's no black people in the jury. The prosecutors exclusive. The peremptory strikes. You got strikes for cause and peremptory strikes. A peremptory strike, each side is issued a certain amount, sometimes 3, sometimes 4. They can strike as many people as they want up until the limit of those peremptory strikes. Strikes for cause means there's some substantial reason that they want to strike this person. Those you kind of have to go over. You got an unlimited amount of strikes for cause and a limited amount of peremptory strikes. But the bottom line is it's like a free a joker. You can just get rid of that. You got the high joker. You got 4 high jokers. Bomb, 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 bomb. I'm out. You see, that's a peremptory strike. Get them out. You don't even have to explain. And so prosecutors were using that to get rid of black people. Okay. And so this case, Batson v. Kentucky, it went up to the Supreme Court and they issued a ruling in April 30th, 1986. And the case came from the trial of James Kirkland Batson. He's a black man from Kentucky, okay, with burglary and receipt of stolen goods. And during the jury selection, the prosecutor used peremptory strikes to remove all 4 black prospective jurors from the jury pool. And so Batson was then tried by an all-white jury in Kentucky, and as you can imagine, he was convicted. And he challenged that. He said, look, the state violated his constitutional rights by removing black jurors because of race. And the United States Supreme Court agreed, and they said under the Equal Protection Clause of the United States Constitution, it forbids the state from purposely excluding black jurors because of race. And the court made it clear that a black defendant does not have a constitutional right to a jury made of black people, okay? But he does have the right to a jury of black people. In other words, you have a right to a jury of your peers, not a jury of your peeps, okay? You understand that? You have a right to a jury of your peers, not a jury of your peeps. And the prosecution can't just remove black people. Now, according in the Karmelo Anthony case, according to CBS News Texas, the jury pool started off with 589 people. All of these are prospective jurors. This is a jury room full of people, okay? After the jury selection, all the qualified black jurors were dismissed by the prosecution. And CBS reported that the prosecution argued the circumstances were race neutral, which is what you expect them to do. We didn't get rid of them because they were black. We got rid of them for other reasons. That one had a wooden leg and a kickstand. That one over there said she had baby daddy issues. And this one right here said his car was on flat. He needed to go down to the Jiffy Lube to get his car checked out. He didn't want to serve it. Race neutral. I know that's, I know those are race neutral, right? And then, you got the defense attorney looking at him side like, I don't know about that, right? But anyway, so that's the issue. Not just the final racial makeup of the jury. The issue is whether the prosecution used its strikes to get rid of the black jurors and then offered explanations that don't hold up. So you had News One reported that the prosecutors used peremptory strikes. Shout out to Black Sands. The prosecutors used peremptory strikes to remove the last 3 remaining black prospective jurors, despite the defense raising the Batson challenge. And it also reported that the prosecutor said that those black women were removed because they were educators of school-aged children. Listen to that. They were educators of school-aged children. I want you to remember that. That's why they said they got, that sounds pretty race neutral. Okay, it's race neutral. They were educators of school-aged children. Okay, and so they were removed because of that. And the judge accepted that explanation. And see, this is where the appellate lawyers, somebody type dream team, this is where they need to dig in. Because educator, it sounds race neutral, okay, on its face, because you can have white educators, Asian educators, short educators, tall educators, whatever. But that doesn't automatically end the analysis. The next question is whether that reason was applied evenly. Listen now, I want you to learn something. Listen, did the state also strike white educators? Did they strike Asian educators? Did they strike Hispanic educators? Or was it just, in other words, did they strike non-black educators? Did the state leave white teachers or white parents or of school-aged children on the panel? Shout out to Terrell Stips. Were the black jurors questioned differently? Were their answers actually problematic, or did they state, or did the state just need a reason after the fact?